Η κρίση του νόμου και της κοινοβουλευτικής αντιπροσώπευσης ενίσχυσε την ιδέα της δημοκρατίας των αντιβάρων και της προστασίας των μειοψηφιών από την τυχόν αυθαιρεσία και τη δύναμη της πλειοψηφίας. Ειδικά στην περίοδο που διανύουμε, κατά την οποία η κοινωνία μας έχει βρεθεί και συνεχίζει να βρίσκεται ενώπιον πολλαπλών κρίσεων, όπως η οικονομική, η πανδημία και η κλιματική αλλαγή, ο δικαστής επομίζεται ακόμα μεγαλύτερα βάρη στην ερμηνεία και την εφαρμογή του συντάγματος. Ταυτόχρονα, οι προσδοκίες που τρέφουν οι πολίτες από αυτό διωγγώνονται. Ο δικαστικός λόγος αποκτά ευρύτερο ακροατήριο και οι αποκαλούμενες στη θεωρία hard cases απασχολούν έντονα τη δημόσια σφαίρα. Σε μείζον στοίχημα ανάγεται εν ώψη των διακινδυνεύσεων της εποχής μας η οριοθέτηση των περιορισμών των δικαιωμάτων. Η πρόσφατη νομολογία, η οποία κλήθηκε να ισορροπήσει σε εξαιρετικές περιστάσεις, κατέδειξε το στενό δεσμό των δικαιωμάτων με το δημόσιο συμφέρον και το γεγονός ότι η σχέση δικαστή και νομοθέτη διέπεται από σύνθετες δικαιοπολιτικές καθώς και τεχνοκρατικού χαρακτήρα σταθμίσεις. Ιδίως κατά την άσκηση του ελέγχου συνταγματικότητας των νόμων, ο δικαστής αναδεικνύεται σε ρυθμιστή των σχέσεων μεταξύ των πολιτιακών οργάνων, σε εγγυητή των θεμελιωδών δικαιωμάτων που κατοχυρώνει το Σύνταγμα και άλλα υπερεθνικά κείμενα και σε πυλώνα του κράτους δικαίου και της δημοκρατίας, προπαντός όταν αυτά βάλλονται. Με τη χρήση των κατάλληλων μεθοδολογικών εργαλείων και κανόνων, όπως η αρχή της αναλογικότητας στο δικό μας δίκαιο, με την τήρηση της δικαστικής δεοντολογίας και την αφοσίωση σε αρχές όπως η αμεροληψία, η ουδετερότητα, αλλά και η ενσυναίσθηση, ο σύγχρονος δικαστής πρέπει να εναρμονίσει τον κανόνα και τα ενίοτε ανατρεπτικά γεγονάτα, δίχως να τα συγχαίει. Το δίκαιο αποδίδεται και εξελίσσεται μέσα σε συγκεκριμένες οικονομικές και πολιτικές συνθήκες. Όμως ούτε μπορεί, ούτε πρέπει να ταυτίζεται με αυτές, ιδίως δε με την πολιτική. Αυτό επιτάσσει εξάλλου η δημοκρατική αρχή και η διάκριση των εξουσιών. Παρά τις διαφορές των δύο νόμων τάξεων, είναι δεδομένη ιστορικά η αξιακή τους εγκύτητα στις μεγάλες και εμβληματικές αποφάσεις των αμερικανικών και ελληνικών δικαστηρίων και η προσήλωσή τους στον πολιτικό φιλελευθερισμό. Σε αυτό το κοινό κώδικα αξιών και πεποιθήσεων βρίσκεται όχι μόνο ο πυρήνας της ορθής απονομής της δικαιοσύνης, αλλά ευρύτερα η εγγύηση του δημοκρατικού και φιλελεύθερου χαρακτήρα του πολιτεύματός μας. Σας εύχομαι καλή επιτυχία στις εργασίες του σεμιναρίου και να περάσετε όμορφα στην Αθήνα. Ευχαριστώ πολύ.
Η Πρόεδρος του Συμβουλίου Επικρατείας, you will now hear from Evangelia Nika, the President of the Council of State of Greece, the highest administrative court in Greece.
Xokotate. Ladies and gentlemen, good morning. You will forgive my accent. I try to speak in English. It is my great pleasure to welcome in Athens, on behalf of the Supreme Court of Administrative Court of Greece, the Council of State, all our esteemed guests who have traveled from so far to join us this week for this program. I also warmly welcome all other distinguished colleagues in the legal profession and friends who are here with us today. It was a year ago, on a very warm afternoon, when Mrs. Konstantina Bagenas arrived from Paros, likely weary from the journey by ship, yet eager to discuss the possibility of hosting a course of the National Judicial College here in Athens. Initiatives like these from the other side of the Atlantic are always welcome in a country and a legal order that has been often intertwined with that of the United States throughout the years. Indeed, let me first mention that it was not so many years after the American Revolution that the Greek War of Independence of 1821 led to the establishment of the modern Greek state. The same values and ideals that inspired Americans also motivated the Greek revolutionaries. This stirred the hearts of Americans, leading to a strong Phil-Hellenic movement. It is worth noting that in Michigan, west of Detroit, one can find the city of Ypsilanti, named since 1825 after one of the leaders of the Greek Revolution. And, of course, as everyone knows, our two states have never found themselves in opposing camps. What is, however, more interesting in the context of this course is the fact that the American model of judicial review, established by the landmark 1803 decision in Marbury versus Madison, was adopted by the Greek courts as early as 1887. The first also judgment of the Council of the State in 1929 carried out a constitutional review of national law. And while this isn't widely known, it is very significant that in Europe this system was the exception and was faced with political suspicion in the majority of European legal orders. And this was the case until relatively recently, when in 1978, the European Court of Justice in Luxembourg, with its judgment in Simmental, imposed the direct and immediate judicial review of the conformity of national legislations with EU law, a position from which I believe there is no turning back. I would like to warmly thank both the outgoing and the newly elected rector of the University of Athens, as well as the university dean, who are always by our side whenever we seek their collaboration for such noble purposes as this course. And of course, I thank the organizing team for all the hard work they have put into this event. Thank you. The topics to be discussed are many and highly interesting, and the schedule of the other events is equally rich. I hope you will all enjoy this program and that it will turn out to be a great success and a memorable experience for us all. Good day.
Dean Sicilianos from the University of Athens Law School.
Your Excellency, the President of the Hellenic Republic, dear Rector, dear President of the Council of State, dear judges, dear colleagues, ladies and gentlemen. It is an honor and a pleasure for me to be here today. The Conference on Judicial Renaissance is the result of the fruitful synergy of the law school of our university with the Council of State, based on a memorandum of cooperation, and with the National Judicial College. It is a sign of openness of our law school to judicial and other institutions in Greece and beyond. Indeed, we have recently signed memoranda of cooperation with the Court of Audit, the Authority of Protection of Personal Data, the Agency of Intellectual Property, and the Greek National Commission on Human Rights. At the international plane, we participate in two networks of prestigious law schools of EU countries and the United Kingdom, through which we have put in place an extensive program of exchanges of professors and students. We have also created two LLM programs in English and one in French, together with the Bordeaux Law School. Furthermore, our law school is participating very successfully in 13 international moot court competitions in international law, EU law, Roman law, etc. The present conference brings together eminent judges and professors from very different legal and cultural backgrounds, the civil law tradition and the common law system. The program of the conference aims at creating bridges between our respective legal cultures, by focusing on some of our most important common values: judicial ethics and judicial independence, human rights, democracy and the rule of law, as well as values and lessons emerging from the writings of some of the greatest figures of ancient Greece. Philosophy and music, classical music, as well as contemporary Greek composers are also part of the program. Let me warmly thank, first of all, Her Excellency President Katerina Sakellaropoulou for her support and inspiring introductory speech. Furthermore, I would like to express my deep appreciation to all distinguished speakers, as well as to our co-organizers for their hard work to make this conference happen. I thank more particularly President Benes Aldana, Professor Keith Fisher and Mrs. Konstantina Vagenas from the National Judicial College, as well as President Evangelia Nika and Councillor Vasilis Androulakis from the Council of State. From the law school, may I thank more particularly Professors George Delis and Spiros Vlachopoulos, as well as the Secretariat and the group of students for their most valuable assistance. Last but not least, may I warmly thank and congratulate our rector and host in this marvelous neoclassical building, Professor Gerasimos Yassios, who has just begun his mandate, and wish him all the best for the years to come. Thank you very much for your kind attention.
You will now hear from the Honorable Benes Aldana, President of the National Judicial College.
Madam President, Kalimera, good morning to all. Welcome to the Judicial Renaissance 3, right here in the heart of Athens. It's great to be, it's a great honor to be here as President of the National Judicial College, and I want to extend my deepest gratitude to each and every one of you for joining us in this extraordinary event. As you can probably see from my tan lines, I was here a couple of weeks earlier visiting the beautiful Greek islands, and if you haven't had a chance to do so, I highly encourage it. It will be a very relaxing vacation, and beautiful and friendly people here in Greece. So. We are truly privileged to have some distinguished guests among us today. First and foremost, I'd like to express our utmost appreciation to Her Excellency, the President of the Hellenic Republic of Greece, the Honorable Katerina Sakellaropoulou, for gracing us with her presence and delivering those thoughtful and welcoming remarks. Your unwavering support for the judiciary is greatly appreciated, and your presence here reflects our shared commitment to justice and the rule of law. I'd also like to extend our heartfelt thanks to the Honorable Evangelina Nika, President of the Council of State, for joining us and for her invaluable contributions to our event from day one when Tina met with her last year. Your presence underscores the significance of the topics we'll be exploring during the Judicial Renaissance. I also want to thank the new rector of the University of Athens, Diarynos Simos, and Dean Siliadis from the University of Athens Law School. Our gathering today and the rest of the week is the result of meticulous planning and tireless effort, and I'd like to take a moment to acknowledge the dedication of the NJC team. In particular, I'd like to recognize Konstantina Vagenas, who American, our Director of Strategic Initiative, for her exceptional organizational skills and unwavering commitment to bringing this course to life. And also supporting her is our distinguished fellow who's been mentioned, Keith Fisher, who incidentally is also Konstantina's husband. Keith, thank you. And I'd also like to acknowledge Tammy White for her valuable support. We all have many bosses, and I have one in the room, and so I want to recognize one of our members of our Board of Trustees, Maggie Anderson, for joining us. Thank you so much for being here with her husband, Lonnie. And also, this is a rare moment for me, if I could take personal privilege. My mom and my twin brother are here. It's rare. This is where it happens. So I want to thank my mom and my twin brother, Ace and Teresa. As I mentioned, this is our third Judicial Renaissance course with previous destinations in Bordeaux, France, and Seoul, South Korea. Looking ahead, we're planning to convene in Lisbon, Portugal, in partnership with the Portuguese Center for Judicial Studies and in collaboration with the Federal Judges Association. And Judge Michelle Childs, the president of the association and a dear friend, is with us this week. Judge Childs, thank you for continuing to be our partner for Judicial Renaissance 4. So if you find this week as enriching as I'm sure you will, I hope to see many of you reuniting with newfound friends in Lisbon in 2024 from September 7th to the 11th. Our Judicial Renaissance course is a testament to our commitment to pushing the boundaries of judicial education. It's a unique journey into the very foundation of justice and a cultural exploration like no other. Our aim is to introduce judges to big ideas within the humanities, ideas that they may not typically encounter in their day-to-day roles. This course is designed to inspire fresh perspectives and foster a deeper understanding of the world around us. Over the next few days, we have an exceptional lineup of sessions led by esteemed experts from around the world. They will delve into topics ranging from comparative judicial ethics to the influence of Greek philosophy and mathematics on Renaissance science, and even the passion of football. When we were trying to come up with topics for Greece, it seems like everything was invented by Greeks. So it was always like from Greek to, whatever. So we're glad to be here, and certainly the birthplace of democracy. While we anticipate many moments of camaraderie and lightheartedness this week, we must also acknowledge the gravity of our times in the judiciary. In many parts of the world, including my home country, no exception, the United States, and many others, democracy and the rule of law, which is democracy's last bastion, face significant challenges. And your commitment to fostering a more just world is deeply appreciated in the face of enduring difficulties. In closing, I'd like to express my gratitude once more to each of you for being part of this unique educational experience. Your dedication to the pursuit of knowledge and the advancement of the judiciary is truly commendable. I look forward to engaging with you all in meaningful discussions, forging new connection, and collectively exploring the intellectual frontiers that lie before us during this judicial renaissance. Thank you, and let us embark on this transformative journey together. Kala na perasete, that means, I hope I didn't butcher it, means, may you enjoy every moment of it. Thank you.
Before we close the ceremony, I would like to acknowledge and personally thank 3 individuals in the room who have been fundamental in getting us to this point today. President Evangelia Nika, thank you so much for allowing this to happen. And Dean Linos Alexandros Sicilianos, as well as Counselor Vasilios Androulakis. He is right there. Counselor Androulakis, if you could just, you were such a big part of this, and we thank you. It's just been such an honor to work with all of you, such brilliant people, individuals who have such a passion for the justice system. It's really been an honor and a privilege. And as we start on this journey together today, in the spirit of the Renaissance, I would like to leave you with the words of the famous Greek poet, Constantine Cavafy. He happens to be my favorite. And from his poem, Ithaca. When you set out on your journey to Ithaca, pray that the road is long, full of adventure, full of knowledge. The Laestrygonians in the Cyclops, the angry Poseidon, do not fear them. You will never find such as these on your path if your thoughts remain lofty, if a fine emotion touches your spirit and your body. The Laestrygonians in the Cyclops, the fierce Poseidon, you will never encounter if you do not carry them within your soul, if your soul does not set them up before you. Pray that the road is long, that the summer mornings are many, when with such pleasure, with such joy, you will enter ports seen for the first time, stop at Phoenician markets, and purchase fine merchandise, mother of pearl and coral, amber and ebony, and sensual perfumes of all kinds, as many sensual perfumes as you can. Visit many Egyptian cities to learn and learn from scholars. Always keep Ithaca in your mind. To arrive there is your ultimate goal. But do not hurry the voyage at all. It is better to let it last for many years and to anchor at the island when you are old, rich with all you have gained along the way, not expecting that Ithaca will offer you riches. Ithaca has given you this beautiful voyage. Without her, you would have never set out on the road. She has nothing more to give you. And if you find her poor, Ithaca has not deceived you. Wise as you have become with so much experience, you must already have understood what Ithacas mean. This is now the end of the official state ceremony. Thank you everyone for being here, and we will now take a 15-minute break before we proceed with the rest of our Judicial Renaissance. Hello, everyone. Again, hopefully you enjoyed the official state ceremony, created especially for you. We're going to try to get started on time. So if you could please take your seats, that would be great. And Laurie, if you could stay in here, Laurie and Nikki. Before we get going, we'll do more official thank yous later, but we didn't want to let another moment pass without thanking Ms. Laurie Poseidon and Ms. Nikki Gonomo. So they are volunteers throughout the year. They have been on the ground here in Greece. Very interesting individuals if you have a chance to speak with them. Laurie Poseidon is from Ohio. She's lived in Greece for over 50 years. She's an expat. Oh, I'm sorry. Sorry. You better talk to her about her. She's a former colleague from Athens College. You know, I was like 20, so everybody, anyway. So Nikki and Ms. Nikki Okonomo, she's originally from Panama and has lived here for a number of years. We thank you immensely. We could not have done this without you. Now, Keith Fisher will tell you a little bit about tonight, quickly, and then we'll, yes.
So tonight we were fortunate enough to secure the Athens Conservatoire for a concert. The concert will begin at 7:15. We have maps and directions for you. It's walkable from here. You can also take a taxi. If you walk it, you'll encounter some nice museums and cafeterias along the way, restaurants. But, you know, obviously you'll have your afternoon free between the end of the program here and then. And then we've been able to get some musicians to play music by Greek composers. We have a pianist and a violinist affiliated with the conservatory. The violinist, I think, also plays with the symphony orchestra here in Athens. So they are Christos Sakalaridis and Phaedon Miliadis, and they will be playing at the beginning a violin piece for violin and piano written by Yorgos Sicilianos, who happens to be the father of the dean of the law school, one of Greece's great composers. And at the end, they will be playing a short suite of popular Greek melodies from the Dodecanis, written by another famous Greek composer, Yannis Konstantinidis. And in between, yours truly will be playing some solo piano music. I will play a couple of short pieces by Konstantinidis, but mostly it'll be Haydn, Ravel, Little Rachmaninoff, Chopin, etc. In my misspent youth, I studied at the Juilliard School of New York, and I have a degree in music theory and composition before I went to law school and went over to the dark side, right? So without further ado, so we hope you'll come. I think it's going to be a lovely event, and it's a lovely facility as well. And also that is the place where some very famous people from Greece studied, including obviously Maria Callas, but also the very famous film composer Mikis Theodorakis, and others too numerous to mention. So welcome to our first program, which is a session on comparative judicial ethics. And we are very honored to have such a great panel of speakers. Each of you, by the way, you're free to speak from your seat at the microphone or to come to the podium as you prefer. And I will introduce each of them individually before they speak so that you don't have a lot of bios coming at you. All the bios are in the online materials to which you will be given links. So I'm not going to try to reproduce all of that information, but just in brief, our first speaker is Michael Pikramenos. He is the Vice President of the Council of State, about which you've heard some this morning. And he's also President of the B section of that court, and he also is a professor of law at the Law School of Aristotle University up in Thessaloniki. He has served as Director General at the National School of Judges here, and has worked with the Ministry of Justice and the Ministry of Administrative Reform. And more than that, he has represented Greece in several different capacities, one in the European Committee for the Efficiency of Justice, another in the group of independent experts for the Assembly of Local and Regional Authorities of the Council of Europe, also in the European Network for Judicial Training, and in the Network of Supreme Courts, which was created in 2017 by the European Court of Human Rights. Councillor Pikramenos is also the author of books and articles in the fields of administrative law, constitutional law, and legal history. So without further ado, Councillor Pikramenos.
Θα ήθελα πρώτα να ευχαριστήσω τους διοργανωτές για την πρόσκληση να συμμετάσχω στην εκδήλωση αυτή και επίσης να σημειώσω ότι το θέμα μου που αφορά τον χάρτη δεοντολογίας των δικαστών του Συμβουλίου Επικρατείας συνδέεται άμεσα με την πρόεδρο της Δημοκρατίας, η κυρία Κατερίνα Σακελαροπούλου, η οποία όταν ήταν πρόεδρος του Συμβουλίου της Επικρατείας όρισε μια ομάδα εργασίας, στην οποία μετήχα και εγώ, για την επεξεργασία του χάρτη δεοντολογίας. Θα παρουσιάσω την εισήγησή μου στα αγγλικά προς τιμήν των φίλων από την Αμερική. The need to open a dialogue on the drafting of a code of ethics for judges in the administrative justice system starts from the Greek judiciary's orientation towards the principles and values of the liberal democratic states of Europe and North America. In this context, the adoption of ethical rules for judges in most European states, USA and Canada, shows the modern orientation of the judicial systems from which we draw inspiration. Our country's position in the world is to a large extent linked to its participation in international organizations and its representation in international fora, where joint commitments are made in order for states to address the dangers that lie ahead and to respond to the challenges that open up in the global community. The Consultative Council of European Judges, which operates within the Council of Europe, issued Opinion 3 of 2002, in which it noted that the rules of conduct are rules of self-control that indicate the ability of the body to reflect on its duties, the values that govern it, notably independence and impartiality, and the powers that have been conferred on it in relation to what society expects of it. Further, in its Opinion 21, Prevention of Corruption of Judges, the Consultative Council of European Judges calls on states to encourage the adoption of codes of conduct. Similar opinions, recommendations, and reports have been issued by associations and organizations within the European Union. In this context, GRECO, Groupe d'État contre la Corruption, in its second compliance report adopted 2020, in the context of the fourth round of evaluation on prevention of corruption with regard to parliamentarians, judges and prosecutors, addressed recommendations to our country on the establishment of clear standards of professional conduct and integrity of judges. Following the international trend of adopting written texts on judicial ethics and following GRECO's recommendation in November 2019, working groups were formed by the presidents of the Council of State and the Court of Audit to draft codes of conduct for judges of the Administrative Justice and the Court of Audit, respectively. This was followed by the establishment of a working group with a similar scope by the President of the Supreme Court, Arios Pagos, to draft principles of ethics for the criminal civil justice system. The Court of Audit published a Charter of Ethics for judges of the Court of Audit in the Government Gazette. Moreover, the adoption of separate ethics texts for each judicial branch is necessary in our legal system, both for procedural reasons and for substantive reasons in view of the specificities of administrative justice in relation mainly to civil and criminal justice, but also the Court of Audits. The draft charter for the judges of Council of State was brought in consultation with the judges of the Council of State and the administrative courts, active and retired, the lawyers, through the plenary of the presidents of the bar associations, and the professors of law schools. The consultation lasted for more than a month, and the vast majority of comments were positive. After the consultation, the working group proposed the draft of the charter to the plenary of the Council of State and was approved. The purpose of the charter is neither to replace nor to supplement the legislative framework which fully and adequately regulates the status of judges, but to set out the values and standards of conduct that flow from it in order to provide a framework of guidelines on the ethical issues that judges face in their daily work in a complex and ever-changing environment which generates new challenges and dilemmas. Nor is this text related to disciplinary law, since its aim is to highlight standards of conduct, the non-adoption of which does not in itself lead to disciplinary liability. According to international theory, judicial ethics texts, regardless of their name, collections, codes, guides, principles, obligations, and origin, Supreme Jurisdictional Councils, presidents of Supreme Courts, assemblies of judges, are in principle of common law character. The present charter, as part of our legal system, does not introduce new law or have a regulatory character. The general guidelines constitute a guide to assist the judges, but also where new areas are approached, the Charter focuses on proposing solutions on behaviors. It is also specifically mentioned in the preamble that its effectiveness is ensured to the extent that each judge individually adopts and applies its principles as a guide and a model for conduct, which implies that the Charter is not imposed on the judge but is adopted voluntarily by him, her, self-commitment. For this reason, moreover, it could not be considered to be prejudicial to his independence, but contributes to strengthening it. In line with international practice, the Charter has a general wording because ethical issues are inexhaustible and highly complex. If the opposite option were adopted, we would have an extensive code which would not only not cover all the issues, but would also give the impression that it attempts to regulate to an excessive degree the daily life of judges, both in and out of office. In the choice followed, the text has flexibility, provides guidance designed to assist the judge in his or her daily life, and at the same time leaves room for the Ethics Council to play its role in the interpretation and development of the Charter by specifying the principles and guidelines in the specific case and by raising new issues. In this way, in future, the Charter will be read in conjunction with the opinions of the Ethics Board, which, on the basis of the questions which the judiciary will be called upon to answer, will formulate a framework of guidelines on specific issues of particular relevance to the exercise of the judicial function, which will be constantly enriched and will give the Charter the necessary dynamism. The preamble of the Charter states that, first, it sets out in a single text, publicly accessible, in accordance with the best international practice of similar judicial institutions, the basic principles of judicial ethics and the standards of conduct derived from them. These standards already exist as an element of the judicial function, as they are drawn from the traditions of the court, some of which have specific aspects linked to the nature of administrative proceedings and are intended to better safeguard the values that emerge from these principles, which ultimately converge in safeguarding the fundamental concept of the rule of law, both in its formal and substantive dimensions. Second, provides a framework of guidance to judges on ethical issues they face in order to demonstrate and to promote a high level of judicial conduct necessary for their effective response to the role assigned to them by the constitutional legislator, as well as to maintain and strengthen the confidence of society in the institution of justice and the authority of the individual judge. Third, it contributes to a better understanding of the role of the judge and the high standards of conduct that she must observe, as well as the specific nature of her duties and the limits that derive from them. And from this perspective, it also functions as a means of strengthening society's trust in the Council of State and the judicial system in general. In this way, the effective legitimation of the judiciary is achieved with the acceptance of its role in the public conscience. The Charter is not intended to describe unacceptable behavior, nor does it provide an exhaustive list of ethical behavior. It sets out a framework of principles and standards and sets out good practice in order to support the judge, but at the same time to activate him or her, making him or her a shareholder in contemporary concerns. It is inspired by the major changes that have taken place in recent years in a number of texts of international and European civil law organizations, in particular the Council of State. The Charter is divided into two parts. The first part sets out the principles, namely independence, Chapter 1, impartiality, Chapter 2, integrity, Chapter 3, decency, Chapter 4, non-discrimination, Chapter 5, professional diligence and competence, Chapter 6, self-restraint, Chapter 7, transparency and communication, Chapter 8. After the principles have been set out, a list of good practices is drawn up to explain and specify their content. The second part provides for the Ethics Board, to which the judges of the Council of State may submit questions on specific ethical issues they face to an advisory board operating for this purpose. Questions may also be submitted by retired judges if they are faced with ethical issues that may have an impact on the authority of the judiciary. The Council is composed of 3 members. It shall be composed of a Vice President of the Council of State as President, a Councillor of State who shall be appointed with their alternates by the plenary of the Council of State, and a judge nominated with his alternate by the Association of Judges of the Council of State. The Charter is focused first and foremost on the level of public service provided by the judiciary. The Charter provides that the authority of the judiciary as a state function is linked to the authority of judges. In that context, an attack on the authority of a judge individually brings about an attack on the authority of the judiciary, and by extension has a serious impact on the authority of the judges who serve it. Therefore, in order to safeguard the prestige of the judiciary, a set of standards of conduct and principles is established which constitute a charter of conduct. The Charter of Ethics includes the fundamental principles of conduct of judges contained in international texts. It is noteworthy that among the principles, it is provided that the judge is aware of and understands the diversity and variety of society and rejects discrimination based on gender, race, color, language, religion, etc. This is one of the most important moral imperatives associated with the pluralistic nature of modern democracy. In the world of legal concepts, the right to difference has been added, which concerns both individuals and groups, and has been shaped since the 18th century and coexists with the right to personal identity. The right to difference is understood not as a denial, but as a necessary complement to human freedom and security in the warmth of a renewed community spirit. The anthropocentric character of the Constitution is incompatible with approaches which are founded on the basis of a more specific substantive status of the person, such as that of national, class-based, religious identity, because all share equally in the value of the human person, have the same right to self-determination, and are entitled to the same protection from the courts, whether they are atheists or religious, whether they are national or foreigners, whether they are white or of another color and race. The above mentioned imposed moral attitude of the judge when dealing with persons belonging to different groups starts from the fact that as a human being and citizen of a democratic society, he accepts that people, despite individual differences, are equal and belong to the same universal moral commonwealth and need not only theoretical recognition but also active protection and real respect. Thank you.
Thank you, Councillor Picromenos. Our next speaker is Professor George Delis, who is a graduate of the Athens Law Faculty, and after teaching as a lecturer at the European Institute of Public Administration in Maastricht in the 1990s, he worked for the predecessor to what is now the Court of Justice for the European Union as a référendaire in the Office of the Advocate General. Currently, he is a professor of public law at the Athens Law Faculty, where he heads the LLM programs in the fields of public law. Professor Delis is also the founding and managing partner of Delis & Partners law firm and is active in the Athens Bar Association. He's the author of numerous books and book chapters and articles on a variety of topics, including administrative law, European Union law, and environmental law. So please welcome Professor Delis.
Thank you very much, and good morning to everyone. I would also like to welcome you in Athens and to thank the organizers for this great opportunity. I'm a bit of an outsider since I'm not a judge, but as I told you, I worked for 4 years at the Court of Justice, and my late dad was a judge, so I have judge genes in my blood. So most of us Greeks here, including me, and due to our continental law background, the US legal culture is rather exotic and a bit unknown fruit. So discussing and comparing topics such as judicial ethics offers the chance to see things differently, see things out of the box, or to see our own cathedral from another point of view. This is a good and a great opportunity for me, and I think for everyone. The exact topic of my presentation, and I will try to bother you for less than 20 minutes, about 18 minutes, will be public functions incompatible with the status of judges in Greece. Necessity or exaggeration. Being a judge, irrespective of the appointment process, comes with several bans and incompatibilities in all legal orders. It will be inconceivable to accumulate the office of the judge with some other lucrative activities. For instance, working as a lawyer at the same time will be the most extravagant example. To be connected to other businesses or to have a rather active presence in other fields, political, ideological, in social or religious matters. Nevertheless, some systems are stricter and more rigid than others, and Greece is one of them. Here, in my country, such a reluctance to allow judges in fields to go beyond the narrow judicial duties is almost unlimited. As I will explain, those incompatibilities cover potential duties of regulatory or administrative nature as well. Is this rigidity necessary and successful in protecting the status of the judges? Or does it generate some losses in terms of efficient public action in the name of a rather excessive fear? In any case, the Greek paradigm serves as an interesting case study as food for comparative thought. Let's start by stressing that in Greece things are as they are for two main reasons. On the one hand, let's not forget that our very conservative continental legal system is completely different than yours, than the American one. It relies on a very formalistic approach on the principle of separation of powers. The three branches, legislative, executive, and the judiciary, are conceived as three totally distinguishable monopolies that should be kept mutually apart, like being waterproof. While Americans adopt a more dynamic and, to my eyes, pragmatic view of separation of powers in the form of checks and balances. We are, in Greece, very far from that. And to preserve this formalism, the judiciary is organized according to the monastic model. Like modern monks, magistrates, this is the term that is for judges used in the official translation of the Hellenic Constitution, are devoted to the worship of Themis, the goddess of justice, since their tender professional age and for life. In Greece, there are only career judges, lawyers that succeed in state exams in their late 20s or in their 30s, and the idea of appointed judges for a limited and specific mandate is strange to us, apart from some very marginal exceptions. In the same line of reasoning, Greek law follows a purely formal definition for courts. Courts are only those referred to by the Constitution and composed by career, or the term is used, by regular judges. There cannot be ad hoc, extraordinary, or hybrid courts. Bodies with quasi-judicial duties, as in disciplinary or regulatory matters, are not considered as courts or tribunals for the reason that they are not composed exclusively by judges, but they have expert professionals working for them. Only criminal courts in Greece include non-judges as members of the jury, and only in certain categories of criminal cases. This is one reason why we have this different approach, a very rigid approach on incompatibilities. On the other hand, the enclosure of judges in the temple of Themis may be explained by historical reasons. Our legal system is the child of a very agitated modern political history that can be separated in three periods. For 90 years, from the Greek Revolution against the Ottoman Empire in 1821 and up to 1910, public institutions, including justice, tried to modernize a newborn state according to the most progressive examples of the West, quite successfully. And then in the next 65 years, the country went through a phase of great turbulence due to wars, crises, national and ideological conflicts. We had division between those in favor of or against the monarchy in the 20s, successive dictatorships. We had Second World War, German occupation, a very hard civil war of 5 years, similar to the Spanish one between nationalists and communists. 15 years of very weak, if not sick, democratic life. It was called quiescent democracy, and a new dictatorship for 7 years from 1967 to 1974. So things returned to ordinary, or became ordinary for the first time, less than 50 years ago, not 1550, with the Hellenic Constitution of 1975. All the above reflect and explain to a certain extent the choices of the Greek legal order on the matter in question, that of the incompatibilities. The ban of incompatible activities is included in all Hellenic constitutions, and we have plenty of them. Since you have an agitated history, you have plenty, many constitutions. 1844, 1864, 1911, 1925. The Constitution of 1952, after the Civil War, stated that it is not allowed to the judge to accept any other remunerated service apart from the one of university professor. Nevertheless, this is tradition. We have Mr. Procuramentos who accumulates those qualities. Nevertheless, during this unstable period, magistrates participated at several sui generis bodies, such as security committees, responsible for imposing displacement measures. This is an euphemism for exile during that period. Moreover, in 1964, the plenary session of Arios Pagos is the supreme civil and criminal court, opined that there is no incompatibility between the offices of judge and minister under the only condition that such mandates are not exercised at the same time. No comments. During the same troubled times, extraordinary and special courts were established in order to bypass the guarantees of rule of law. Last but not least, cleansing of political dissidents serving at public authorities included also judges. During the last military regime, this happened many times. With the restitution of democracy, the Constitution of 1975, apart from establishing strong guarantees of personal and factional independence, clearly provides in Article 89 that magistrates shall be prohibited from performing any other salaried service or practicing any other profession, with some exceptions. Members of the Athens Academy, teaching staff at the university level. Furthermore, participation of magistrates in the government is prohibited according to paragraph 4 of the same article, with one exception. This is interesting. Following a constitutional amendment from 1986, if the political parties may not form a sustainable majority in the parliament to support the government, the president of the Hellenic Republic, as a last resort, appoints the president of one of the three Supreme Courts, Council of State, the Supreme Administrative Court, Arios Pagos, or the Court of Auditors, which is the third Supreme Court, to form a transitional cabinet to carry out new elections. This is the only exception. Yet the Constitution of 1975 allowed the appointment of judges to special administrative courts or to councils or committees. Such provision made it possible to assign specific administrative duties to judges even as a full-time activity for a limited mandate. The opportunity has been successfully and frequently used for 25 years, even for positions rather close to the political hierarchy of the ministries. A member of the Council of State was appointed and detached to occupy the office of the General Secretary of the government at that time. The situation changed with the Constitutional Amendment of 2001. According to the new paragraph 3 of Article 89, which is still in force, assignment of administrative duties to magistrates is prohibited. Judges may only sit on councils or committees exercising competencies of disciplinary, auditing, or adjudicating nature and on bill drafting committees. They can also represent the country in international organizations. In other words, in Greece, we do not like our justices to have an active role outside courtrooms. Not only the Constitution, but our judges do not feel comfortable to assume such roles as well. From my personal experience, it is rather difficult to persuade them, with some exceptions, to come and teach at the university. Everybody seems to feel safer this way. But let's look at those provisions and bring them to this fundamental choice of the Constitution with a more critical eye. Firstly, some conceptual clarifications. The term extrajudicial activities that describes what is in principle prohibited for judges is the direct opposite of what we could define as judicial duties. Okay. Nevertheless, the latter lack of any homogeneity and they are not restricted to dispute resolution. In Greece and I think elsewhere, courts undertake a variety of non-adjudicational duties. The Greek Council of State, the Supreme Administrative Court, is called by the Constitution to express ex-ante opinions on the legality of normative presidential decrees. And it's a very successful provision, very important duty. The Court of Auditors exercise a number of purely administrative functions. Criminal courts deal with the execution of sanctions, which is not an adjudicational competence. Even the Arios Pagos is involved by the Constitution to the electoral process by officially acknowledging the candidates and the parties' lists. Those competences are judicial from a formal point of view, but have nothing to do with what we would call rendering justice through the sword and the scale. Under that light, the separation between judicial and extrajudicial activities does not follow a functional criterion, but rather an institutional one. Of judicial nature are the mandates that the legal order attributes to judicial institutions, the courts, irrespective of their nature. Extrajudicial are the mandates that could be potentially attributed to specific judges outside the courthouse. The difference lies in whether the assignment goes to the institution or outside it ad personam to the person of the judge. Furthermore, it is important to stress that those extrajudicial potential activities, and more specifically the public ones that could be endowed to magistrates, vary considerably as for their characteristics and the risk that they entail. A Supreme Judge serving for some years as the General Secretary of the government surely raises concerns about judicial independence. This is not the case if for a judge offering expertise to an administrative authority for a limited time. Apparently, those restrictions are imposed to safeguard the personal, institutional, or functional, as it's called, independence of justices. This is the official reason given in Greece. After traumatic experiences for several decades, an absolute general ex-ante ban of all potentially risky situations seemed to be the safest solution. To use a metaphor from Homer, since we heard Homer today, the legal order prohibits to Judge Ulysses to navigate towards the island of Anemoessa and not to listen to the song of the sirens at all, even if he could be safely attached to the mast. In addition, the independence of an institution could be undermined not only because of corruption or of the accumulation of clearly incompatible activities, but also through other means of indirect capture, revolving doors, moral hazard situations, etc., etc. The American legal doctrine has taught us, continentals, a lot about that, and this is correct. So why not deal with those undesirable situations by using the most radical cure? Having said that, it is important to see the other side of the coin as well, especially regarding the non-attribution of competencies of administrative or regulatory nature. The latter are obviously different than exercising a second profession or occupying a political seat. Working for the administration for a limited period without accumulating judicial work in parallel may generate notable positive externalities. It produces a surplus in quality for the beneficiary public institutions, for the citizen, and for the judges themselves. The modern mission of Themis is, in the field of public law, is not just to resolve disputes, but to efficiently face and cure all state failures by any means, by the most efficient means. This is also the correct reading of the separation of powers. If the participation of a magistrate at the preparation phase improves the quality of a public decision, such an involvement presents an important institutional benefit. Losing it due to constitutional rigidity is not insignificant. Moreover, the risk of judges being submitted to or suffering from improper influences is a real one and will always exist even with the draconian bans of the Hellenic Constitution. For example, I use some Greek examples. Offering a judge a position at the National School of Judges, Thessaloniki, or to participate at a sensitive disciplinary council could do the job. Allowing acting justices to become members of an arbitral court, which is provided for by the Constitution, is already high risk. Even the prospect for a judge at the end of his or her career to serve as president at an independent administrative authority can be a rather melodic siren, okay, for being less harsh when reviewing governmental choices. At the same time, it is irrational to prevent acting justices, acting judges, to temporarily leave the courts to become members of a regulatory authority. In fact, the fact that in Greece we often compose those bodies, those independent authorities, with former judges is the best confirmation of how precious the participation of experts with judicial background in those non-judicial institutions is and can be. There will always be shadows and triumphs, whether we imprison Judge Ulysses in the hold of the vessel or not. Protecting him and the legal order cannot be ensured by stretching the incompatibilities, but through another antidote, which is no other but transparency, to my eyes. Instead of prohibitions that do not prevent from behind-the-scenes synergies, it would be better to have clear and official appointments of magistrates in public positions outside the judiciary. Transparency goes along with accountability, and what we heard is those timid steps of Greek legal order towards accountability in Greece that makes the judges more careful in their decisions. Contrary to that, the regime in force creates a sense of safety which is fictitious. it operates as a chastity belt. While at first sight it seems to create confidence that there will not be any conflict of interest, in reality it intensifies the mistrust towards the person concerned, the judges themselves. It is as if without this chastity belt, it would be impossible to ensure a virtuous behavior. Personally, I consider those draconian prohibitions more as an expression of poor institutional confidence than as a means to increase the authorities of the judiciary. In brief, restricting justice from an important number of competencies of administrative and regulatory nature has a negative side as well. It cuts off the breadth of themes from aspects of real life and public action where they could offer a lot. Thank you very much.
Well, ladies and gentlemen, we were originally planning to take a break now, and we can still do that. But since we're in the cradle of democracy, I'll offer you a choice to vote if you prefer to have a short break now, or if you want to soldier on for another 45 minutes and finish this session and take a longer break at the end of that. So how many people want a break now? A few? You can always, of course, discreetly. And I guess that means the rest of you would rather soldier on? Yeah. Okay. See how inspirational it is to be in the home of Demosthenes? Okay. Our next speaker is Judge Margaret McEwen, who is Senior Circuit Judge on the United States Court of Appeals for the Ninth Circuit, a court on which she has served with distinction for many years. I believe she's a native of Wyoming. She is a member of the American Academy of Arts and Sciences, is an affiliated scholar at the Center for the American West at Stanford University, and is a jurist in residence at the University of San Diego School of Law. Judge McEwen is a graduate of Georgetown University Law Center, which has also bestowed upon her an honorary doctorate. And prior to her appointment to the federal bench, she was the first female partner at the Seattle-based law firm Perkins Coie. Among her other distinctions, Judge McEwen is a past president of the Federal Judges Association and is a former chair of the Codes of Conduct Committee of the Judicial Conference of the United States, which is the committee that issues opinions on judicial ethics issues. In 2022, she authored a biography of U.S. Supreme Court Justice Douglas entitled Citizen Justice, The Environmental Legacy of William O. Douglas, Public Advocate and Conservation Champion. Please welcome Judge McEwen.
In the spirit of soldiering on, thank you. I do want to thank the University of Athens and also the Council of State and the National Judicial College for bringing us together. I think it's really an amazing opportunity. And of course, for years, my passion has been this topic of judicial ethics. We are, as we know, in the midst in the United States of a very controversial conversation about judges, both state and federal, on ethics issues. And there's this tension between the view of the judge as a monastic being and the view of a judge as a citizen in the community. And Professor Dallas rightly pointed that out. The same tension exists here in Greece. Now, the ethics rules in the United States, in my view, tip to the judge as a player in the community. But the question is, well, what are the boundaries? What are the guardrails? So to understand the evolution of how we got to where we are, I think it's helpful to take an historical journey. So that's what I plan to do today. I will invoke what Justice Holmes said, that an ounce of history is worth a pound of logic. So we will go on a short historical journey on the ethics codes in the United States, because I think it helps us to understand how did we get to where we are today. You know, formal ethics codes are actually a creation of the 20th century. But in the spirit of this Renaissance program, I want to say that the whole spirit of ethics actually goes back to the Roman Code of Justinian and this notion of judges being not ever under suspicion, but needing to recuse themselves. We saw that move forward in the 1300s in England, the same principles. And we now have them not only in the United States, but internationally, the Bangalore principles in various countries, which have adopted versions of these. Now, in the United States, in 1789, we had the Judiciary Act. And here's what the act said. It applied to justices, and judges to do equal right to the poor and the rich, and to faithfully and impartially discharge the duties of the office. And that really kicked off this notion of the impartial judge, but also a judge who exists in a system where we have separation of powers and judicial independence. Now, today, all judges and justices are governed by a statute that basically mirrors that concept, which says that a judge has to disqualify himself, that's the way our codes are written, in any proceeding in which his impartiality might reasonably be questioned. So interestingly, the way that we got our judicial codes is really through scandal and controversy. They did not really pop up through some good-spirited notion. And let me tell you how it first started, through American baseball. So here it is, it's 1919. The Chicago White Sox players, 8 of them, were accused of basically fixing the game. They later became known as the Black Sox. The game was against the Cincinnati Reds. So the allegation was that a gambling syndicate had actually supplied the money. So Major League Baseball was in the midst of a scandal, and it says, well, what should we do? We need to clean up our act. How best to do that? Let's get a federal judge. And the federal judge can come in and be the new commissioner of baseball. So that's what they did. They appointed a gentleman who had a really improbable name, Kennesaw Mountain Landis. So Judge Landis becomes the commissioner of baseball. But there's a huge outcry. How can he be the commissioner of baseball and be a judge on the federal court? Well, nobody knew the answer. There was no code of ethics. So the public pressure required him to choose. We know what he chose, commissioner of baseball. Do you think it had anything to do with the fact that there was a substantial salary increase over this federal salary? Well, I don't know. I think baseball's interesting, but for me, I would take the federal judiciary. Now, yes. So interestingly, those players were acquitted in a criminal trial, but Commissioner Landis then basically permanently suspended them. So here we have this conundrum of there is no code of ethics. So Chief Justice Taft formed a committee in conjunction with the American Bar Association. And it's interesting because he had politics in his bone. He had been the president of the United States, and then there was a hiatus, and now he's Chief Justice. He never got rid of politics. He was hobnobbing at the Republican convention. He was talking to the president about everything from labor unrest to foreign relations. But he created our first code of ethics. And there were 34 canons. It was kind of complicated and unwieldy. But a number of those principles are the same ones that we have today. Appearance of impropriety, avoidance of politics, and importantly, they noted that a judge was not required to surrender his rights or opinions as a citizen. Around some years later, the Supreme Court had a case that kind of encapsulated this notion that judges are citizens. Here was the case, O'Malley v. Wood. A federal judge had sued and said, judges don't have to pay income tax. Oh, good idea. But legally wrong, said the Supreme Court.
But Justice Frankfurter used this language, and he said that to subject judges to a federal tax is merely to recognize that judges are also citizens. Now, Justice Douglas, about whom I've written, really took this to heart. And so he said, if I can be a citizen, I can do anything as long as it doesn't interfere with the work of the court. And believe me, he did. He went on to do environmental lobbying, advice to the presidents, etc. So this notion of what is a citizen justice, I think is fantastic. The question is, what are the guardrails of being a citizen justice? But importantly, in that very first code, one of the things that was written in was the importance of extrajudicial activities, and basically saying that judges could be within the community. And we were told that judges should not live in retirement or seclusion, that a judge should continue to mingle in social intercourse, and he should not discontinue his interest in or appearance with meetings of the members of the bar. So that's really the foundation which a lot of us engage in when we engage in community activities. Well, of course, scandal had to come along, and we then had another scandal, Abe Fortas, which many of us remember. He was nominated by President Johnson to be Chief Justice. But the scandal was that he had actually been consulting with President Johnson on political matters, and he had also received about $15,000, which back then was maybe 40% of a justice's salary, from speaking engagements. So President Johnson withdrew the nomination. He stayed on the court. But ultimately, there was another scandal about income he received from a foundation. And of course, he resigned from the court. It's interesting that this notion of outside income also affected Justice Douglas. There were impeachment proceedings against him, not because people disagreed with his opinions, which they did, but because he had worked with a foundation which did work in Latin America, and the charge from Congress was that this should be illegal for a judge. So eventually, Chief Justice Warren, he's seeing all these scandals, and he says, we have to do something about it. So we have our first code back in the 20s, and the next code wasn't even revised till 1972. And again, it was a scandal. So we revised the code in 72, and then again in 1990. And that's the foundational code that we all live with. In 1990, the code changed its language from judges should do this and judges should do that to judges must. So apropos of the code that you're talking about, the code became more mandatory than hortatory. But interestingly, on the federal system, we stayed with the guidelines and the hortatory code. So I think it's interesting to see where Greece has landed and where we are with some split between most state codes and the federal code. So importantly, judges are encouraged to pursue community and civic activities. And interestingly, although it was the Chief Justice that prompted this change in the code, Supreme Court justices are not covered by the code. And the reason for that, according to the justices, is that the Judicial Conference has authority only over the lower court judges. That's me, lower court judge. But the highest court, the Supreme Court, makes its own rules. And of course, we know in recent times they've adopted some additional principles that they all signed off on. And Chief Justice Roberts has pointed out that they also abide by the federal code. We have, like Greece, a part of our federal judiciary where judges can ask opinions about ethical issues. I chaired that committee. And in fact, Supreme Court justices do ask the committee for opinions. But I think most importantly, and something that the press always misses, is that this statute that we have, 28 U.S.C. Section 455, applies to both judges and justices in terms of appearance of impropriety. So I want to just briefly talk about some of the things that judges or justices were doing before modern day. Justice Frankfurter said, well, the court is a monastery. I have to say that's some monastery that guy was living in, because he was out there campaigning for Zionist rights. He was advising President Roosevelt on all manner of political things. And we also had justices running for president. Well, we talked about Taft from earlier, but in the 19th century, a number of justices either contemplated or literally ran from the bench. And by the time we got to the 20th century, we had the same thing. We have Chief Justice Hughes saying, oh, this would be terrible for a justice to run for president. So he resigned and lost his election. We then had Justice Douglas, and he had what has been called the presidential bee. He always wanted to be president. And his high school yearbook, in fact, said he would be president. And his mother basically said he would be president. Well, it didn't happen. But when Roosevelt was choosing a vice president, the question was, who would it be? Would it be Truman or Douglas? There's a little piece of paper that said Truman, Douglas, or did it say Douglas, Truman? No one can find the paper, but we know Truman was appointed, so Douglas was disappointed. Then Roosevelt died, and he was like a father to Douglas. Roosevelt dies, and Truman asked Douglas to be his vice president. Here's a guy who always wanted to be president. Douglas says, why be number two to a number two? And he declined the vice presidency. And he said, kind of interesting, the work of the court is long and enduring. So over a 120-year period, there was no 10-year period in which some justice wasn't angling to be on the Supreme on as a president. But you know, President Roosevelt, like many presidents, has actually treated justices like a think tank, if you will. And so we had justices advising the president on many things. And we also have the justices doing the president's bidding. Most notably, we had Justice Jackson, who went to Nuremberg as a prosecutor, not a judge. And we all think back, beginnings of international law, and how incredible that was. But think about it. You have a justice who's been confirmed by the Senate. He leaves the court, he goes to Nuremberg, and he becomes a prosecutor. It was not exactly well accepted by all the justices. But, you know, that's what happened. And then, of course, we had Frankfurter advising Roosevelt on the war and many other things. So it's interesting that you mentioned that Greece has this possibility of this transitional cabinet, and also the possibility to leave the court and go out and come back. We don't have that possibility, except if your name is Justice Jackson, and we're coming out of this incredible situation with the Nazis and World War II. The president then appointed Chief Justice Warren to head up the Kennedy Assassination Committee. What could be more political than that? So basically, in the 20th century, we have a lot of examples of these intersections between politics and the justices. You know, less so now, I would say. We've certainly had our controversies, and I won't go through all of those. We had Justice Scalia and the claim that his friendship with the vice president should put him in hot water in terms of hearing a case involving the vice president. We had Justice Ginsburg, who criticized Trump during the campaign. But interestingly, as the justices have moved away from the more overt political action and withdrawn from that, they've actually become better known than ever. And how do they do that? Well, through books and also TV appearances, anything from CBS News to the Colbert Report to many other things. So the justices really are very public figures now, and some judges are as well. But I think we've seen that while the justices in prior years were overtly and quintessentially partisan and political, that there's been this fascination because of the way U.S. judges and justices are appointed, nominated by the president, confirmed by the Senate, that there is this underlying political architecture, if you will. But I would say in closing that thankfully we have these questions. You know, what is partisanship? What's de facto partisanship? And thankfully our ethics rules, both on the federal and state level, permit us to engage in a wide variety of civic, charitable, education, religious, social, and other activities. And I would suggest to you that this participation in civic life both legitimizes the judiciary, it educates the public on the importance of the separation of powers. It provides expertise in areas where judges' expertise is useful. And I think it also reinforces the judiciary as an independent branch of government. Thank you.
Thank you. So I'm going to try to bat cleanup here. Well, that's good. We may need some technical assistance here. Let's see. Oh, no, here it comes. Okay. I might just say as a postscript to what was just being discussed, that, well, two things. Number one, Judge McEwen mentioned two very high-profile situations, the Nuremberg trials and the Warren Commission in the 20th century. Both of those, of course, came before the adoption of a code of conduct for the federal judiciary in 1972. The other thing I want to say about them is that they were not isolated instances. You can go back to the dawn of American history. So, for example, the very first Chief Justice, John Jay, also served as Secretary for Foreign Affairs, and he was subsequently appointed by George Washington to negotiate our first international treaty with Britain, known as the Jay Treaty, coincidentally. And John Marshall, who was Chief Justice, also served as Secretary of State while he was judge. And throughout the 19th century, there were numerous justices who served on commissions, and some even mediated international disputes. So you got the first Justice Harlan mediated the Bering Sea dispute, and then Justices Brewer and Fuller mediated a boundary dispute having nothing whatsoever to do with the United States. It was between Venezuela and Guyana. So there's a bit of history there. So I'm going to try to focus on some of the extrajudicial activities. These, of course, are the rules in the Model Code of Judicial Conduct, which is the product that is the successor to the canons of judicial conduct, the origins of which Judge McEwen told you about, arising from the famous Chicago White Sox scandal. The ABA Model Code, as you all know, is not the law anywhere. It's up to each individual state to adopt it. But these are most states have adopted it, more or less verbatim, some less. But there are lots of variations. And so other codes of conduct also use those same principles. We've already talked about the states adopting the Model Code. Judge McEwen talked about the Code of Conduct for U.S. judges, which was adopted from the 1972 version of the ABA model code. Since that time, the ABA has amended that code several times, and so have many of the states, but the federal code hadn't really changed that much. And it's also contains principles that are accepted internationally, as you can see from the citations here of some of the values that are identified in the Bangalore Principles of Judicial Conduct, and that, by the way, is a picture of Bangalore. So there's also a linkage to fundamental human rights, because many of the international instruments guarantee rights to a fair and impartial judge, and I've just listed a few of them on here. I put a C, so you have, of course, the Universal Declaration of Human Rights from the UN founding, and then you have the very well-known International Covenant on Civil and Political Rights, which has been adopted by, I think, 173 countries. And then you have the European Union, you have some other regional conventions that are listed here. Interestingly, the US Constitution nowhere in so many words guarantees anybody the right to a fair and impartial judge. It does say some things about the right to public trial, right to an impartial jury, not an impartial judge, right to effective assistance of counsel, right to confrontation. All of these ancillary rights, kind of taken as a whole, contribute to getting a fair and impartial judge, but it's not expressed in the American Constitution. It is, however, expressed in the codes of conduct, and we'll get to that very shortly. Some of this history